G'day, I'm Michael Tessaro, and this is the ACCC cheat sheet for August 2025. And if you haven't seen these before, effectively it's a summary of everything that happened in relation to ACCC in that particular month. So summarise all the press releases and any other relevant issues. Bit of background about myself: I'm a competition and consumer lawyer, and I've been running my own practice, Tessaro Legal Consulting, for the last 18 years, and I help companies, individuals with competition and consumer law matters. Also do some advice work and consultancy work for some of the legal publishers about competition and consumer law. I also have a part-time role as general member of the Consumer and Commercial Division of NCAT in Sydney, in New South Wales, I should say. And in that role, I get my opportunity to consider some real-life consumer law cases. Prior to that, I worked at the ACCC for 15 years in a variety of roles. And I guess most relevantly, I was the Director of Enforcement in Sydney and the Director in charge of the Sydney Mergers and Asset Sales branch. Outline, pretty similar. Courts, 3 court cases. Limited enforcement mergers. It was a scam awareness week was during August. Again, limited authorisations and inquiries and a couple other matters. Now, the big case in August was the full federal court case in BlueScope Steel. And this is an appeal by BlueScope and an individual, Jason Ellis, against the first decision by Michael O'Brien. And in that case, he found that the conduct to be engaged in effectively attempted cartel conduct and imposed a penalty of $55 million against the company and a big penalty against Mr. Ellis for being knowingly concerned of the conduct. So there's an appeal on the liability issues, and the full federal court upheld the earlier decision that the company, through Mr. Ellis, had sought to induce 8 other steel competitors to enter into a cartel arrangement. Effectively, it was a depressed time in the market, and he was trying to get them to sign up to a price list which would increase the prices. In addition to the 8 distributors, he also approached an overseas manufacturer. So he's been pretty diligent trying to get all these people to join up. And Mr. Ellis was also appealing a decision by Justice O'Brien, that he not be allowed to use his director and officer's insurance policy to cover his penalty. And that was decided against him. I think the case could go to the High Court. I'm not too sure if BlueScope actually challenged the size of the penalty, $55 million. I think I would have had a go at that if I'd been there, but I didn't see it in the appeal decision. I haven't read it yet. I just sort of flicked through it. But definitely, I think Ellis will want to go to the High Court on the directors and officers policy issue. Mainly because there's been another decision by Justice Stewart and the Productivity Partners where he went the other way. He decided that the relevant person there, Mr. Wills, could use his policy to avoid paying the penalty. And so there's a difference of opinion between these two cases, and that should be resolved. And I think it's got to be the case that Justice O'Brien's correct in this case. Like, you can't have people insuring out of the risks to pay a penalty under the Australian Consumer Law or any other Competition and Consumer Act or any other legislation, because it does undermine the policy of the Act, which is to put the sting of the penalty on the individual and not to have it, paid by an insurance company. So I think O'Brien's right. I think Stewart and Productivity Partners is wrong, but that might give some basis for an appeal. The other case that came down in August was the Delta Automation appeal, and I have a conflict of interest. I have an interest here that I should disclose. I've done a bit of work for Delta Building Automation. They basically hired me after litigation had commenced to help them set up a compliance program. I trained the compliance officer and all their staff and drafted policies to help them show to the court that they had taken these steps. And actually, all the things that I developed, like my training and everything, was filed in the case. I put an affidavit on, explaining to the court what I'd done to help them out with their compliance. And I guess what I'd done was commented on favourably by the judge. Justice Bromwich commented that it was quite helpful that a person like me be involved in helping Delta Building Automation get on top of compliance. I'm not sure that ACCC agreed with that anyway. So the thing here was there was a meeting between Mr. Davies, the owner of the company, with his competitor about the upcoming tender. It was just a coffee shop meeting, went for less than 5 minutes, And the allegation was that Mr. Davis was seeking to enter into a tender arrangements to rig a tender for providing automation services for the National Gallery. And the court determined that that was established, and Delta was ordered to pay 1.5 million, and Mr. Davis won 20,000 respectively. So that appeal, the full federal court upheld the initial appeal decision of Justice Bromwich. Now, I can't help looking at these two cases and wondering, how can you possibly compare them? You just can't compare them. Now, just comparing some of the elements of it, BlueScope at the time had a turnover of 8 billion. Now, I looked the other day, its turnover is now 16 billion. It's doubled in the period of time between the breach and now. And they were fined $55 million, and that represents 0.68% of its turnover. It's a very small number when you think about it. Then you look at Delta, much smaller company, $21 million, fined $1.5 million, 7% of its turnover. So how can you hit BlueScope with a fine that's less than 1% and Delta with a fine that's 7%? And the other thing I should add is that the fine the ACCC were initially seeking at Delta were 2.5. And it was sort of reassuring that Justice Bromwich looked at the subjective factors, the seriousness of the conduct, the compliance steps that were had been undertaken by the business, and knocked $1 million off the penalty being sought by the ACCC. They went from 2.5 to 1.5. But it just doesn't make sense. One's wrong, or they're both wrong, but the two cannot stand together. And then when you look at the nature of the breaches, like I actually said 8 attempts, probably 9 attempts because I forgot the manufacturer. So you got 9 attempts over a 9-month period. It's actually concerted, premeditated, calculated effort by a senior manager to try and enter into a price fixing agreement. And Delta Automation, 1 attempt, a 5-minute coffee shop meeting. They're so different. If this is relevant factor, surely BlueScope should have been fined much more than Delta, relatively speaking. The other thing is a bit bizarre. I went through Justice O'Brien's first decision on liability and his penalty decision to try and see if he said how big the market was for flat steel products. And he didn't say it anywhere, which is sort of a bit bizarre. Like, clearly, if you're looking at attempted price fix the market, you've got to sort of know how big the market is. Like if you're trying to set a market, trying to fix a price in a market that's worth $10. It's a lot different to if you're trying to set prices in a market worth $10 billion. But I can't see it anywhere. Maybe I just missed it. But I estimate the size of the flat steel products market, so just the flat steel products market, was $2 billion back in when the conduct occurred, 2015, I think, around there, 2014. So if you're looking, that's how big the market was. And then you look at Delta Automation, it's a tender to the National Gallery worth $745,000. So you've got a $2 billion market and you've got a $745,000 tender, and one guy's being done with less than 1% of the turnover and the other guy's getting 7%. So I think it's a real problem. I don't think we can have decisions on very similar provisions of the Act which are just so different and which look like the more serious conduct as being too low and the less serious conduct is too high. And I think probably a lot of blame here goes back on the ACCC because they're the ones making the submissions. They should go back and they should look at the relativities between different cases, and they should be making sure there's some relativity. But they're not doing that. They're just sort of going as hard as they can in every particular case. As I said, Delta Automation, they initially went for 2.5, which as far as I can see was like more than the maximum. I don't know how they went for 2.5 because it was 10% of turnover back then. So it was like the most they could have paid was 2.1. Anyway, so this is a big problem. I think something needs to be done. And I think the activity needs to be undertaken by the ACCC. They need to be comparing cases when they're preparing penalty submissions. The other case was ACCC and Mosaic Brands, and there was it was not 29-25, sorry, it's 2025. The court decided that a penalty of $25 million should be imposed against Mosaic Brands. There's no judgment as far as I can see, and the allegations were that Mosaic Brands failed to deliver a lot of products within the relevant time frames over all its brands, and actually 4,000 products weren't delivered at all. So it's major failure in terms of meeting delivery times. ACCC also established that Mosaic Brands did not have reasonable grounds for claiming it to be able to deliver these products within those times because it knew it had this defective warehousing and logistics system and operation. So it knew it was taking orders, but knew it couldn't meet the time frames. And then they also, just to add something else, they were saying on their, I shouldn't laugh, but this is just bread and butter stuff. How they could be getting this wrong, I don't know. Effectively saying that consumers didn't have the appropriate consumer guarantee rights. They had 6 months from when they purchased the good to return it. Now, this is a silly case in my view because Mosaic Brands, as probably most people know, have gone liquidation. And so there's no fight being put up by Mosaic Brands here. The liquidators have agreed, yeah, run the case ACCC, but you're never going to get a penalty out of us and you can't get any costs out of us. So ACCC is running this case to get a Phoenix fine. They're never going to see any of this money. They're not going to get any costs, just wasting their money. And I just don't know why they do it. It doesn't make any sense. These cases, as far as I'm concerned, don't establish any specific general deterrence. Businesses ignore these cases, you know. Courts pretty well ignore these cases because it's not a contested case. And I think what the ACCC needs to do is, if they sue somebody and the company go in liquidation, drop the case, unless they've sued some individuals. And here, I don't know why they sue some individuals. Surely some individuals at very high levels in the business must have been aware of these problems, must have been allowing this conduct to continue. Sue the individuals. And if you're suing some individuals, yeah, keep the case going in liquidation. But if you don't have any individuals, just drop the case. They have scarce resources, ACCC. I don't know whether they're wasting money on these particular cases. Enforcement Google. Now, this was a very, very serious breach. Basically, Google entered into agreements with Telstra, Optus, and TPG, although this only relates to Telstra and Optus, whereby they said, we're going to give you a big bunch of cash if you allow us to be pre-installed and the exclusive search engine on all your Android phones. That's a massive, massive breach of the law. It's an exclusive dealing agreement, probably 45 if you don't want to go exclusive dealing. Anyway, it's a massive breach of the Act, very, very big impact on competition. And a few months ago, Telstra, Optus and TPG entered into undertakings with ACCC where they promised not to do this anymore and get rid of the existing agreements. So they dodged the bullet, didn't get fined. But now the ACCC has sat down with Google, cooperated, they've admitted we did the wrong thing, and they agreed to a penalty of 55 million. Now, I don't know about you, but 55 doesn't seem like a lot. Like, this is seriously anti-competitive conduct. Went for a few years, impacts every Android mobile phone in the market, kept competitors out of the market. 55 million is a parking fine. So I don't know whether ACCC agree to that. I would just say to Google, okay, we're going to take it all the way, and we're going to get a big penalty, which probably should have a zero after that. You know, $50 million. So I don't understand this case at all in terms of why they agree ACCC agree that penalty. Maybe the judge might say it's too low, might double it, but they're not going to add a zero to it, that's for sure. So again, I think maybe the ACCC is selling this a bit short, this case. You know, it was in place for 3 years. They're keeping competitors out of the market by having these exclusive deals. Okay, next case, Harvey Norman. So it's going from sublime to ridiculous here. Here you got a very, very small case, and it relates to this franchise disclosure register where franchisors are required to put some pretty minimal information on this register, and basically this franchisor, McGregor franchisor, failed to put the documents on there. So it's a pretty minor matter. It's a $15,000 fine. Now, the one thing about the franchise disclosure register, it used to have an obligation to put quite a lot of juicy information in their particular disclosure documents, but somehow the franchise lobby got out of their obligations to put all that on there, and now it's, in my view, pretty useless. It doesn't have anything of any interest. I used to sometimes encourage franchisees to go have a look, compare different franchise disclosure documents, but there's no point nowadays. So I guess that's just an aside. I think it promised a lot, but it's really not doing very much at all, the disclosure register. A merger, and this was a merger of two companies I've never heard of before, MicroStar and Convoy, and these companies are involved in the market for the supply of keg pooling services to brewers. That makes sense, you know, you buy beer, you get a big keg, all the pubs get these kegs delivered to them, and these two companies appear to have a very big position in that very niche market. Effectively, they've got this massive shared pool, and people can get them on a short-term basis to get liquor into their stores. Now, I guess the thing here, the reason the barriers are probably high is because it's like when you think of those pallets, the pallets for moving goods around, chip pallets. It's not the biggest technology in the world, and it's fairly easy to replicate a pallet, but it's the scale. Like, how can you replicate thousands of pallets? If you're a new entrant, it's a massive initial investment to replicate that massive pool of products. And the same here, I think. A new entrant would have to come in and manufacture thousands of kegs in order to compete. So I think that's probably why the ACCC might have found this was preliminary concerns about this particular merger, because it's a big collection of assets, which is very difficult to replicate. The market feedback looked at alternatives to keg pooling, and they're talking about leasing, ownership, etc. And the ACCC concluded that they weren't valid substitutes or close substitutes, which makes sense. One thing that's interesting here is convoys in administration and receivership. Now, that might be bad management, maybe there's not much money in this market, I don't know. But the key thing here is it could be a failing firm argument, but the way failing firm works, it's not like, oh, I'm going broke, I should be allowed to be bought out by my competitor. What the ACCC looks at is whether the assets are going to leave the market. So if there's kegs and somebody's going to sort of buy the asset out of liquidation and use the kegs for some other purpose, I don't know, to plant flowers in or something, then that means the assets are going to leave the market and the market will be underserviced. But if the goods are very specific to the industry and they're going to, even in liquidation, going to be bought by somebody who's going to continue to participate in that particular industry, then the ACCC prefers that outcome. So it's only when the assets are going to leave the market, the ACCC might say, okay, failing firm. But if the ACCC believes the assets are going to remain in the market through the liquidation process, they may prefer that option. It was Scams Awareness Week, 25th to the 29th of August. I think this one passed me by, unfortunately. But National Anti-Scam Network got together with a bunch of organisations to try and just promote a lot of awareness about scams. So you can see government, business, community groups, consumer groups, educational organisations, etc. And they're trying to promote this idea of stop, check, protect before you click anything online. I think my personal advice would be stop, delete, because the second you stop and you have a look at it, you can see that it's dodgy. You don't have to really do much much research to know you're being scammed. I think a lot of that stuff is where people just think something is familiar or think it's from the correct organisation, click on it. If you stop, check, I guess that's probably right. Stop, check, delete's probably with scams. So I guess there was also a bit of report on how things are progressing, and it was sort of like good and bad news. The first one was the number of reports, 108,000, is a decline from the same time last year. So the first 6 months of 24, they had 24% more claims. So I think you could probably say about 130,000 complaints. And so it's declined from last year, which is good. Which is good if you're saying that means less people are being scammed. Maybe it means less people reporting scams. I don't know. But you'd think on its face that's less people being scammed. But the problem was that the value of the amount scammed has risen significantly. So even though having 24% less scams reported, 26% increase in the total amount of money lost. So I think that would suggest that scams are becoming more sophisticated and people are losing more money. So it's $173 million in the first 6 months of 2025, which is 26% higher than the previous year. So it's gone in the wrong direction. Okay, soft plastic recycling. The history here is interesting. There was a company called Recycle that was getting all this plastics and claiming to recycle it, make money and all the rest of it. And then I think they were running this sort of like shell game there for a while where they're just storing all this recycling material in all these warehouses. And then finally, the secret came out that they weren't actually recycling anything. They were just stockpiling it because they couldn't afford to do it. And it all came tumbling down. The company went in liquidation. And so there was a pressure on, I guess, these businesses. What are we going to do? So they've been exploring ways of getting together to deal with the massive stockpiles of products, and then to work out a system going forward which can deal with the issue on a cost-effective basis. So the ACCC has issued a draft determination. So they're saying, yes, we think there's a benefit here, and we'll let you guys try it out. But now they're going to seek comment from various groups as to what they think about that. Voluntary industry-led scheme to collect and recycle soft plastic. I think a lot of environmental groups might be not happy with it because it's sort of the people creating the problem are now going to, I guess, regulate the problem. So I've already seen a couple of environmental groups coming out saying it shouldn't be business doing this. It should be the government. I probably agree with that. It's a big important issue, and I don't know why the government's not getting into it. So basically, the proposal is to set up a soft plastic stewardship Australia organisation, and then a bunch of companies are going to be on the board, all the big retailers and some of the big manufacturers, and they're going to be trying to work out ways of continuing this recycling program, but fundamentally making a little bit of money out of it, for the reason that they don't want to do this forever. They want to basically set something up, make sure it's profitable, and then flog it off to somebody else to run. They don't want to do this. It's not core business for them. Now, the ACCC thought there were significant public benefits and that outweighed the potential anti-competitive detriment. I think the benefits are huge and the detriment's probably pretty low. Can't see it becoming a hotbed for cartel conversation. So that makes sense. And they're proposing to grant the authorisation for 8 years and have reporting requirements to make sure it's all very transparent. I guess the plan here is that try and work out a system that's profitable, and then these guys can get out of it and let somebody else do it. Batteries is an interesting one. It's been around for a while. I don't think it's a very successful code. I don't think it's voluntary. A lot of people don't sign up. A lot of dodgy batteries in the market. Batteries aren't really made with the long term in mind. Let's make a battery that can be recycled. That's not really part of a lot of people's business model. So it's not very successful, but I guess ACCC has issued draft determination to allow them to try and improve the whole way of recycling batteries. So the Battery Stewardship Council operate a scheme to facilitate disposal of end-of-life batteries. There's some safety issues here because some of these lithium batteries get into garbage and they just sort of catch fire and create fires, particularly down at the landfill. Often fires are starting there because something combusts and then all the methane, catches fire. So basically, they're trying to develop ways of improving the end-of-life disposal of batteries. There's clearly significant environmental health and safety benefits from this. The problem is that it's voluntary. A lot of people don't sign up, so there's no commitment. So ultimately, maybe if they can't get something over the line, maybe government will step in and introduce a mandatory system. Now, this is a misnomer. Domestic airline competition report. Like, it seems to suggest there's some competition happening in our domestic airline market. There isn't. So I think it should be the domestic airline lack of competition report. And it's just classic duopoly behaviour. It's like a case study. Like, guys should be writing PhDs on this sort of stuff. The number of passengers flying domestically each month has returned to pre-pandemic levels. That's great. However, growth in the total number of seats provided by domestic airlines has not kept pace with traveller demand. So despite having a lot of demand, the airlines haven't met that demand by putting more output on. Why not? It's classic. When you look at price fixing and reducing output to drive prices up, it's just classic duopoly behaviour. And that's what's happening here. They're not putting enough seats on, keeping the prices high. Now, further concern, despite fuel prices for jets falling 12.3% in the year to June 2025, average airfare across all fare types rose. So here you've got, you're not putting enough output into the market to meet demand, forcing prices up. Your costs are going down, your prices are going up. So these guys have just got a classic duopoly operating at the moment, and there's no incentive for them to compete. The other thing is on-time performance rate for domestic air travel reached a 3-year high. I guess it's a bit of good news, but Why do they keep cancelling all these flights? And that's because of yield management. If they're sending a plane to Canberra and they're going to make X dollars, and they can redivert that to Sydney and they're going to make X plus Y dollars, they're going to redirect it. They don't care about the people in Canberra. And that's always been the problem. And it always seemed to me a bit silly to be treating people flying in and out of Canberra so badly, because you think got a lot of those people are probably politicians, and you're stuffing them around. So you're sort of the people who could do something to regulate this whole problem are being disadvantaged. So this is very bad news. I don't know what's going to happen. I don't know what the proposals are. I thought the proposal might be to let some of the international airlines run their planes on domestic routes. Sometimes they need to get a plane from one place to another place and it just goes empty. Maybe they could just sort of say, okay, we'll run a domestic flight from here to there and provide some competition. But apart from that, I can't see any other competition coming to the market. Let's face it. Who'd enter this market? You'd be insane to enter this market after all the failures. Electricity industry report. Now, this is a bit confusing. The ACCC issued this report at the beginning of the month, and I didn't quite understand what motivated it. Now, clearly, the next stage in solar is to provide solar batteries, and the government's really into that. The feed-in tariffs are pretty well gone, so the only thing you can do if you've got solar panels and you're generating a lot of electricity, you can't really sell it and make any money nowadays. So you put it in a battery and use it later on. So that's very sensible. And the government's kicking a lot of money to support households to buy these batteries. The ACCC is warning everybody, the battery and solar suppliers, electricity retailers, that they must meet scrutiny as demand for this increases. Now, I don't know if they are aware of a problem or they're worried there may be a problem. I guess I do quite a lot of work for some very large solar retailers in Australia, and it's a heavily regulated system. I don't know really why you'd be so worried about it. It's the most regulated system I've ever come across, and it's very hard to do anything without somebody requiring some paperwork, whether it's a clean energy regulator or the solar organisations in each state, such as Solar Victoria. So I'm not too sure whether this is preemptive. Maybe it is, but I don't know if there's a lot of bad conduct happening at the moment, particularly in relation to batteries. I don't think the batteries are really out there very much at the moment. And they're calling for additional consumer protections to safeguard consumers. I don't know if you need more. Just sort of enforce what's out there at the moment. I don't think I'd be calling for any new laws. Then later in the month, in the other category, Choice issued its first super complaint or designated complaint to the ACCC. And the way this works is three organisations have been given the right, Consumer Federation, these guys, and COSBOA, to lodge a designated complaint with the ACCC, which they must investigate unless it's just like totally outside their jurisdiction. And here, what Choice has asked them to investigate is whether energy retailers are misleading consumers by promoting energy plans that promise savings or value that are actually not good value. So you're thinking that sounds pretty like misleading conduct, like laws that are already in place, and you think the ACCC is already pretty all over that. But obviously, Choice has identified, some additional concerns. I think some retailers are using particular terms which they sort of, to an average consumer, probably convey the same meaning, but they actually convey different message. The underlying message is different, so that can be misleading. So the ACCC has decided to, investigate this, particularly the consumer confusion arising from retailers' use of identical names for plans with different rates. So that's going to be very problematic. The thing is, there's a lot of energy comparison sites that people can use, and you think that any confusion that might arise can be ameliorated by that. The other thing here is COSBOA hasn't done a designated complaint yet, so the pressure's on for them. Carbon Market Institute Summit. I don't really know much about this, but Gina Cass-Gottlieb was invited to give the keynote speech, and it's actually quite a good speech. Like, she didn't say anything like earth-shattering, like anything new, but she brought together all the stuff the ACCC does and explained how it sort of relates to the things that the Carbon Market Institute might be interested in. So obviously, the way competition, climate, ACCC's role, looking at how they do their enforcement, looking at various exemptions, that are available, particularly for environmental, authorisations and environmental benefits. How merger control is going to be relevant here, and I think it's probably not specifically relevant to this industry, but just generally relevant. Natural monopoly infrastructure regulation probably pretty relevant, particularly in relation to coal loading facilities and access issues. Market studies, so looking at various markets to see if they're functioning well, and then finally, the future regulation. So clearly, sustainability collaboration, which the ACCC approved recently, ensuring that any collaborations that try to improve environmental outcomes are good. So it's quite a good speech, the way she brings everything together and draws it back to the what would be of interest to the members of this particular summit. There's a few comments. I think I've probably said enough about BlueScope. It's just BlueScope and Delta, the two cases came out the same day, but when you put them next to each other and compare them, they just can't be compared. It seems to me that probably BlueScope was too low and Delta was too high. And one thing I'll probably say about small businesses, like I know the ACCC is very keen about cartels, but sometimes you just got to say to yourself, this guy said something he shouldn't have said. He probably regrets it. How about we just give him a warning? How about we give him an A7B undertaking? Like, I actually did that once ACCC. Sometimes I get a complaint, some small business engaging in some dumb conduct, potentially cartel conduct or retail price maintenance. I just ring them up and I'd say, hey, I'm a director from the ACCC. I've had this allegation. If you're doing this, stop doing it because you can't pay the fine. Sometimes they'd argue with me. I'm saying, give me a warning. You can take it on board, or we'll be back here in a few months' time and there'll be litigation. And I used to do that. And I think there's a lot to be said for that, to just give people a bit of a warning. Here, BlueScope penalty, it's very bad conduct, very big market, lots of attempts, went for 9 months. And then Delta, very small company, relatively bigger fine, looking at turnover, a 5-minute meeting, very small, one single tender. And it's the ACCC's responsibility to make sure this doesn't happen. When they're preparing their penalty submissions, they've got to make sure there's some relativity. I remember when I was preparing some documents for a fine against Woolworths many years ago, when we did them for some breaches of Part 4, I went through and I found all the other cases, compared them, and looked at all the different subjective factors and tried to get this big table to sort of justify what the penalty was. And that's what the ACCC should be doing. I think it makes sense. You just can't ignore other penalties in other cases and go for the max, as seems to have been the case in Delta Automation. In actual fact, they seem to go for 2.5 million, despite the fact the company only had a turnover of 21 million. Mosaic Brands, again, this is my little hobby horse. And when I'm interviewed by the people doing the ACCC inquiries into their performance, I often tell them this: don't take litigation against companies. Don't maintain litigation against companies that go into liquidation unless there's a personal respondent, because it's a waste of their money. They have limited money. It's not going to achieve any specific deterrence because the company's gone, and it's going to achieve zero general deterrence. Everybody in business ignores these cases. The first thing they say, wow, did they pay 20 million? It's, no, they didn't pay 20 million. It's a Phoenix fine. The money's never going to be paid. And the first thing business people say to me, why did they bother? Why did they bother taking that case? And it's hard to say, they think it's going to scare other companies into obeying the law, and they go, well, I don't think so. So it's just a silly thing that ACCC do. They should be suing more individuals, particularly when a company's teetering on the brink like Mosaic was. There were definitely some senior managers, even directors, who could have probably been sued personally, and they should have done that. Google complaint case it's a very, very serious breach of the law, very premeditated, very damaging to competition, keeping competitors out of search engine market for Android phones. $55 million is a ridiculous fine to agree to. Just run the case, put it before a judge, and get the fine that you should get. It's just not high enough. And I think the ACCC, they get a bit dazzled by the number 55. They should be thinking much, much bigger. Like here, it should have been well in excess of $100 million, this fine. So hopefully the judge might say it's too low and double it. That's what they should do. Super complaints. Well, that's two of the three designated complaint organisations have filed their complaints. The first one was about uh, phone telemarketing type sales, door to door, lead generation. I think it raised some interesting issues, that first one. This one, quite specific about the way particular offers are um, described. Probably worthwhile having a look at it. And then the pressures on Cosboa, the third of the three approved designated complainants, hasn't done one yet, and so the pressure's on there to get one in there with the ACCC. One I think would be really cool is that I've been reading a lot about sovereign citizens, and it's funny, there are a lot of sovereign citizens running around Australia. We see a lot in NCAT, unfortunately. And unfortunately, an industry has developed around there where people develop these training documents, and videos, and books, and sell them to sovereign citizens, explaining how they can use this pseudo law to avoid liability for, speeding fines and various things. And so people are exploiting sovereign citizens by selling them these books that are just totally misleading. And I reckon that'd be a pretty cool designated complaint because, if you could just cut off the misleading information that a lot of these sovereign citizens are relying upon, but not just relying on, they're buying them. They're buying these things from other people. If you could, stamp that out, maybe you'd have less sovereign citizens carrying on. Because you pay some money for a book and you think it's all very credible, and you run those arguments, you get slapped down in court. But if you just cut it off at the first stage where the books are being sold, that'd be a significant public service, I think. Plastics, the final issue. I just don't see why the government's not involved in that. Hopefully, the individual companies can get a system going and they can make it somewhat profitable, and then a third party comes in and runs it for a profit. Ultimately, I'm sceptical that's going to be achieved, in which case the government's going to have to step in. But I guess the government's just hoping that the industry can sort out the problem themselves and then they don't have to step in. So that's all I had. A bit longer than I'd hoped. I think maybe I got on my high horse a bit today. So 37 minutes. So sorry about that. If you have any questions about this video, feel free to give me a call or drop me an email. Bye bye.